My name is Dr. Carla Hewitt, and I'm going to walk you through the process surrounding reopening of closed medical benefits for physician reviewers. In 2011, sweeping changes were adopted for Montana workers' compensation in the Montana Code Annotated 39-71-704, including adoption of fee schedules, UNT guidelines, medical status form, and a 60-month termination of medical benefits. In addition, the statute 39-71-717 allows for the reopening of terminated medical benefits and has charged the Department of Labor and Industry to develop the process to handle the reopening of the terminated medical benefits. 39-71-717 specifically outlines exceptions to reopening. The reopening of medical benefits does not apply to medical benefits that are closed by a settlement or court order, or to those who are permanently, totally disabled, or those with a prosthesis. Next, we'll review each of the steps outlined in the statute regarding the specifics of the petition. A medical director review only versus a panel review, who provides the medical records, and what happens in 2 years after the initial review. There are levels of evidence in the legal system and are termed substantial, preponderance, clear and convincing, and beyond a reasonable doubt. Clear and convincing is the level of evidence that is typically used for criminal proceedings. Preponderance of evidence, which means a tittle or a slight tilt of the scales of justice in favor of the party, or 51% of the weight of evidence. This is the level of evidence that is used in civil and family law settings. Preponderance of the evidence is the level mandated by 39-71-717 when considering the reopening of closed medical benefits. All things being equal, if the evidence presented is just 1% in favor of one party over the other, then that is the party that the decision must be made in favor of. Medical benefits are to be reopened only under 2 scenarios. The medical treatments are to allow the worker to stay at work, or there is a reasonable expectation that the medical treatments will get the injured worker back to work. It was not envisioned, and the law does not support the reopening of medical benefits for those who never recovered and never returned to work. The burden for requesting the reopening of closed medical benefits is on the injured worker or their representative. The vast majority of these requests will therefore come from the worker. In rare instances, it is appropriate that the insurer knows that it's the right thing to do to keep the medical benefits open. To attempt to streamline the process and to be able to arrive at a reasonable decision with the minimal amount of information, the department designed a petition form for the injured worker to complete. If the worker completes this form and provides all the information on the form, even in the event there is no medical records provided, it is envisioned that the decision can still be made. There will be times the insurance carrier and adjuster know that the right thing to do is to reopen the closed medical benefits. This being the case, the statute envisioned a streamlined process in which both parties are in agreement and can agree to the reopening. The department developed a joint petition for this event, and following the direction of the statute, will have the review be by the medical director only rather than a full physician panel. Both forms are designed to allow for written permission by the injured worker to release the medical records. This streamlines the process and minimizes the back and forth between the department and the injured worker. By signing the petition to request the reopening of benefits, the injured worker is also giving permission for the release of personal medical information to support the petition. This is the start of the process. There is a review to determine if there is a valid petition received and no evidence of excluded conditions. The insurer is notified in writing. The insurer has several responsibilities in the process. The insurer needs to let us know if the claim has not been accepted and is being paid under rights of reservation. In addition, the statute specifically states it is the responsibility of the insurer to provide the medical records to the department's contractor. Given that the statute gives a hard and fast deadline for decision-making, 60 days, the department determined in its work process that it absolutely needs the medical records that are already in the insurer's file within 14 days of notification. In this era of electronic medical records and electronic medical record storage, the request for 14 days processing was thought to not be an unreasonable request. It needs to be understood by the insurer that if no medical records are provided by the 14-day deadline, the petition will move forward with the information that the department has on hand. Please remember the preponderance of evidence will be used. If the only information that is provided is what the injured worker has provided, then that is what the decision will be based on. A tool that you will need in your reviews is that the requested medical service has to be consistent with the Montana statute and utilization and treatment guidelines. Here is where you can find the UNT guidelines. Also, as a panel reviewer, you need to be familiar with the disallowed procedure statute. If there is a request for reopening of medical benefits, those benefits cannot be in conflict with this statute. For example, an injured worker cannot request reopening of medical benefits for medical marijuana, as medical marijuana is specifically excluded under Montana workers' compensation. Here is a screenshot of the panel member review form. The dates when received by Maximus, the date when the report must absolutely be completed, the deadline, and the actual date of completion are all important. In addition, it needs to be indicated if this is an initial review request for reopening of benefits or if this is the every 2-year review. You, as the medical panel reviewer, must indicate your opinion. Either the benefits are reopened or do not reopen. Whatever the decision, it must be supported and given a rationale for the decision. The date for reopening should be completed as well. When you, as the panel reviewer, complete the form, you will need to sign and acknowledge that you reviewed the records submitted, that the review was carried out consistent with statutory requirements, the condition being treated is in the direct result of a compensable injury or disease. In addition, please acknowledge that you used the preponderance of evidence to arrive at your decision. At the 2-year review, there is no change from the original recommendation, then the medical director will complete the review. But if there is a material difference in the evidence and the medical director determines there could be cause to change the original recommendation, then the department will request a panel review and the review process will be the same as the initial review. In the follow-up review, the 2-year review slot will need to be checked. If there is a disagreement with the panel review decision, the law allows the injured worker or insurer the full measure of appeal through the Workers' Compensation Court after the mediation procedure. If you have any further questions, please contact me by the email or phone number listed on your screen.